I can't get adjusted to it.
Okay.
I feel like I've been grumpy.
I now declare this hearing to be in session. We are here to hear case number BOA 250902229. Will all wish to testify, please rise and take the following oath. Your wife going to testify? No. Oh, you don't have to. Okay. Do you solemnly swear or affirm under the penalties of perjury that the testimony you are about to give will be the whole truth and nothing but the truth?
Yes.
Mrs. Maxwell, have all postings and notification requirements been satisfied? And any matters to relate to jurisdiction, this board will now be heard. Let the record show there were none. We'll now hear from the Department of Planning and Zoning. Mike.
Good evening. I'm Mike Golds. I'm a zoning inspector with the Queen Anne's County Department of Planning and Zoning. We're here to discuss the Board of Appeals file number BOA 250902229 submitted by Patrick Baltzer and Nicole Egerton. The project location is 1010 Love Point Road. They are proposing to remove the current deck located on the rear of the home and construct an addition to the existing single-family home of a 16 feet by 21 feet screen porch and a 19 feet by 16 feet deck with steps to grade. The request of action, the applicant is requesting a variance to construct a 16 by 21 foot screen porch and a 19 by 16 foot deck 35 feet from the rear property line. In accordance with Chapter 18, 1 through 19, E, 1C, 4E, III, the required rear yard setback in the NC 15 zoning district is 50 feet. The parcel is located on map 48, block GG, parcel 149, lot 26. It's approximately 0.35 acres on 1010 Love Point Road, Stevensville, Maryland. It's in the Cloverfield subdivision. The property is improved with a single-family dwelling and an accessory structure. The parcel is zoned Neighborhood Conservation, NC 15. The entire parcel contains hydric soils. Non-tidal wetlands exist on the parcel. However, they are not in the project area. The property is located within the community of Cloverfield's subdivision, Plat 6, recorded on September 9, 1959 in Stevensville. It is a conforming lot in NC 15 zoning district. The current primary structure was constructed in 1998 and is approximately 53 feet from the rear lot line. There is no record of of a permit for the existing rear deck, which shows up on the GIS map between 2004 and 2008. It's currently in current NC 15 rear setback is 50 feet. The owner is seeking a variance to reduce the required 50-foot rear setback to 35 feet to construct an addition to the existing single-family dwelling of a 16 feet by 21 feet screen porch and a 19 feet by 16 feet deck with steps to grade. Under 18, 1 through 19E, 1C, 4E, III, a 50-foot rear yard setback building restriction line is established and required within the Neighborhood Conservation NC 15 zoning district. The property is part of the Cloverfield subdivision that was created prior to any zoning regulations. The rear property line abuts lots 12 and 13 along Mason Road. The applicant proposes to remove the existing deck approximately 16 feet and 47 feet located approximately 35 feet from the property line. The deck is illegally non-conforming. This deck is illegally non-conforming as there is no permit on file. The deck addition will be approximately 35 feet from the rear property line. The NC 15 zoning district requires a 50-foot rear yard setback. Zoning staff has not received evidence that outlines the practical difficulty regarding the property. The applicant must present clear evidence of a practical difficulty to the Board of Appeals.
Any questions? We're now going to enter the applicant's exhibit 1 through 6. And the plan and zoning was presented by Mike O's. We're ready for you to tell us what you'd like to have, what you'd like to do.
Yes, so we purchased the property in 2022. When we had our inspection done, we didn't know that the deck was not permitted. So when we submitted our application to build a screened-in porch, we were surprised that it got kicked back with the information that there was not a permit for the deck, so it could not be permitted. So we would like to submit the permit to rebuild the deck in kind, in place with a new deck with the screened-in porch.
Is it going to be the same footprint, basically?
Exact same thing.
Tear all the old one out, everything.
As much as we have to, yeah. I mean, we have concrete footers in the ground surrounded by gravel, so ripping those out would be tough. And the deck itself is in great condition. The only reason it needs to be torn down is because it doesn't have a permit. So there's nothing wrong with the deck. It just has to be demolished in order for us to, at this point, have a deck and have a screened-in porch.
Tell us a little bit about why you want or need the screened-in porch and the deck back there.
The screened-in porch, the reason we started the process to get one is that in our area, the mosquitoes are so bad that being outside is almost unbearable. So we wanted to have a screened-in porch so the kids could still be outside.
It's problematic for your kids to be out back some certain times of the year.
Yeah, pretty much the whole summer.
Is that a safety thing as well? I mean, to keep the kids from getting closer to the water?
Yes.
Anything else?
And you'd mentioned, you are gonna remove the deck that's there, or you're gonna, if you get a new permit, you're gonna leave the existing deck and then enclose that, or?
We would like to salvage as much of the existing deck as we can. We're not sure to what degree that can be done with the permit and everything. If, like I said, functionally and structurally, the deck is sound. So there's nothing wrong with it. It just wasn't permitted. So we have this situation where we need to demolish it in order to have a permitted deck.
Would you say that a backyard deck and, an enclosed or screened-in porch are fairly common features for that neighborhood?
Yes. Everybody around us pretty much has them. Our back neighbor has one, and I'm kind of trying to copy what he has.
You'll probably have to leave those footers in there if they're in cement now. You'll probably have to leave them in or you'll tear up everything.
Yes, and everything under the deck right now is gravel, which would make a big mess.
Anything else?
I don't think so. I mean, the only thing I would say is, as I kind of said it previously, but as much as the deck as we could salvage.
So that's what I was about to ask you. Are you of the mindset that you have to tear it out? Like if they issue the permit, I don't think any of you would indicate that he has to tear it out. So I think you could leave as much as you'd like, as long as it's in the footprint of the permit.
Yeah.
So I just want to make sure that was understood, because I got the impression you feel like you might have to rip it out and replace it just because.
Well, that's what we were really hoping not to have to do. But
So-
yeah, I didn't know.
Yeah.
So no, I appreciate the clarification. That is welcomed information.
As long as it's approved, I don't know what they're going to do in a minute. However, to the extent it's approved, you wouldn't need to take it out and put it back.
I mean, this is pretty straightforward as far as I'm concerned.
Yeah,
I'm good.
that's right, yeah. Those in favor of granting this application will now be heard. Anybody else would like to speak? Let the record show there were none. Those opposing? Let the record show there were none. We're pretty much ready for the criteria.
Okay. To grant the variance, you have to consider certain factors under 18-1-21. First, 121.c, the ability to use the property for any reasonable purpose, whether or not such purpose is desired by the appellant in the absence of the proposed variance. You have to consider
Yes.
that, do you consider that factor?
Yes,
The degree to which the proposed variance will affect adjacent property owners.
Yes.
yes.
Really doesn't. It's already, the existing footprint's already there.
The
And there
im-
was no testimony against.
The impact of the proposed variance upon the resource protection provisions of Part 4, Article 9 of Chapter 18.
Yes.
The degree to which the situation might be more properly addressed by amending Chapter 18.
Considered if
Considered
it's
it.
outside of our purview.
Okay.
Yeah.
We have to, guys. 121B, to grant the requested variance, the board must find as follows: that a literal enforcement of this chapter 18 would result in unnecessary hardship or practical difficulty as a result of the specified conditions.
Yes.
Those conditions are peculiar to the property involved.
Yes.
Those conditions are not the result of any action taken by the appellant.
Yes.
The variance will not be contrary to the public interest.
Yes.
An evaluation of alternatives proves the variance is required.
Yeah, there's really no alternative.
Okay, and then finally, the board under 122A must find that any variance granted is no greater than the amount minimally necessary to every single time I get on that word, ameliorate the conditions giving rise to any practical difficulty or unnecessary hardship.
Yes.
That's it.
We're ready for a motion.
Sure. In regard to case BOA 250902229, I'd like to propose a variance to reduce the required 50-foot rear yard setback to 35 feet in order to construct a 16 by 21-foot screen porch and 19 by 16-foot deck.
I'll second that.
All in favor?
Aye.
I now declare this hearing to be adjourned. You will receive a formal decision as soon as possible. We'll take a 5-minute break.
I see they're getting no snow, so I think I'm just gonna go to.
Sounds on. Okay, we're now,
I'm gonna kick myself, I think.
now declare this hearing to be in session. We are here to hear case number BOA 250802226. Will all that wish to testify please rise and take the following oath? Do you solemnly swear or affirm under the penalties of perjury that the testimony you are about to give will be the whole truth and nothing but the truth? Mrs. Maxwell, have all postings and notification requirements been satisfied? And any matters related to jurisdiction, this board will now be heard. Let the record show there were none. Department of Planning and Zoning will now be heard.
My name is Bill Baum, and I'm a zoning inspector with the Queen Anne's County Department of Planning and Zoning. We're here to discuss BOA number 250802226. The applicant is proposing to replace a pier in kind which extends 202.2 feet channelward from mean high tide. The total project includes an 8x10 walkway landward of mean high water, an 8x150 portion of existing pier, an 8x10 portion of existing pier to be redecked, an 8x15 existing L-shaped platform to be redecked, and a replacement piling cluster for a total length of 202.2 feet. The applicant is requesting to replace an existing pier in kind with improvements at a total length of approximately 203 feet from mean high water. This parcel is identified as tax map 9, parcel 117. It totals 1.6 acres. The address is 204 Truslow Farm Lane. It is an improved lot with a single-family dwelling with direct frontage on the Chester River, southeast of Chestertown. This parcel is zoned Neighborhood Conservation 2, or NC2. As you can see by the colors on the slide, the parcel contains a wide variety of natural resources, none of which will be disturbed. Located in the critical area, limited development area, LDA, there is floodplain and possible tidal wetlands along the shoreline. No hydraulic soils are present. Parcel 3 was created in 1979. SDAT lists the principal structure being built in 1917. The pier construction appears on QAC GIS aerial imagery between 1963 and 1978. The current pier is 202.2 feet in length. The applicant is requesting a variance to replace an existing pier in kind with improvements at a total length of approximately 203 feet from the mean high water line. In accordance with 18-1-41 piers, a pier is limited to 150 feet from the mean high water line. More specifically, a pier may not extend into any body of water a greater distance than 150 feet as measured from the mean high water line unless the Board of Appeals approves an application for a variance seeking a greater length. In no case may the length of a pier exceed 1/2 the distance from the mean high water line to the center line of the body of water. The pier was constructed at its current length between 1963 and 1978, according to QAC GIS. The pier meets the limitations established in 18-1-41 regarding the distance from mean high water line to the center line of the body of water. The proposed pier is consistent with the approval the applicants received from the Maryland Department of the Environment. Zoning staff has no objections to the approval of this variance. The applicant must present clear evidence of practical difficulty.
Mr. Stevens, we're going to present.
One sec. I just have one. Mr. Baum, on that, and I may have missed it, was it permitted? Were you able to find a permit for it originally?
No, we have no record of the pier being permitted.
Okay. At that time, was it legal at that time?
Well,
That
it
length.
appears between 1963 and 1978, so there would be no code requiring a permit in 1963. So I don't know exactly when it shows up.
All right, thank you, sir.
Any questions? No. Mr. Stevens, we're going to enter applicant exhibit 1 through 9 and planning and zoning presented by William Baum.
It's just a note, the parcel, when it was created in 1979, it does show a pier on the property.
So the 19, just for a clarification point, Mr. Baum, the 1979 subdivision does show the existing pier. Okay, thank you.
Go ahead.
Thank you, Mr. Baum. Thank you, board members.
Joseph Stevens, Centerville, Maryland, on behalf of the Schmidts. I have essentially two witnesses. I have Julia Schmidt, who will come up here with her husband, Timothy, but Ms. Schmidt will be doing most of the talking. And then I have the surveyor who did the survey work, who did the soundings. He's just going to testify to what he did so that you have it on the record, that it was done professionally in accordance with the standards of the industry and so on. So just as a preliminary matter, this is a variance, relatively new variance requirement under the code, has been revised about a year and a half or 2 years ago, where it requires a variance and not a conditional use to exceed 150 feet. This is a complete in-kind replacement. The pier is 178 feet long. The 202 feet are to the outer pilings, which is where you measure to. Those outer pilings exist, so it's just a replacement in kind, no wider, no longer than what exists, and there's a boat lift there too as well, and there'll be a replacement of the boat lift. And so what I'd like first is to have Ms. Schmidt come up here, and her husband Timothy can come up as well, and I've just got a few questions for him, and I want him to address you. I have a few exhibits, but you already have them. I'm just going to give them to you so you don't have to flip through the whole application as I'm referencing a couple of things. So if you could sit down here. Yep, please, thank you. Could you both identify yourself for the record, please, and speak into the microphone? And
My
you're
name
on
is-
camera. So,
My name is Julia Schmidt.
Timothy Schmidt.
okay. And you're the owner of the property
Yes.
subject to the application. Could you just, for the board, give them a little bit of background, how long you've owned the property, and then also discuss some of the challenges associated with the property in constructing a pier of only 150 feet and reconstructing that?
Absolutely.
Okay.
So we bought the land in June of '24, so about a year and a half ago, and we bought the 1 acre parcel where the house is and the pier currently exists. We also bought about 3.5 acres immediately adjacent, which is completely unimproved, and we have no plans to improve that whatsoever. There's no pier, no structure at all there. So we have been renovating the house, and we're hoping to be able to be in there really soon, which is exciting. The problem with the existing pier, as you can see, is the water depth where it comes into the land is very shallow. So in that particular section of the river, despite the fact that the river width is very wide there, it's about 2,000 feet across, it actually jogs in along the shoreline on our particular parcel. So if you look at the adjacent parcels, like at a Google Map overview of the river, other people's piers come out and they get to sufficient water depth being shorter than
Does this
ours.
exhibit that you included in your application show an adjacent pier getting to sufficient water depth, and then your pier and the distance needed to get to sufficient water depth?
Correct.
And
So-
this is your existing pier, is that right?
Correct.
Thank you.
Yes.
You have this again, but I want to give it to you just so you don't have to flip through that.
So our immediately adjacent neighbor, Ms. McIntyre, has a pier that is shorter than our existing pier. And there, as you can see, the river packet is maintained there, and there's sufficient water depth for that. My brother-in-law actually keeps his boat on that pier as well.
Let me just, so the owners of the property next to you are your brother-in-law?
No, I'm sorry.
Okay.
Third party owns the land
Okay.
next door. The river packet, which is a publicly charterable boat, is kept there. His brother also keeps his smaller recreational boat on the pier adjacent.
Okay.
And
So
for,
this-
for the record, we're not going to enter this because it's
Do
already on
not
the
need to
record.
enter any of
Right.
these, no, I'm just for
Yep.
convenience purposes.
But just for comparison, as you sort of look along the shoreline, you can see where it jogs in at our parcel, and therefore we have a much wider shoal than a lot of the adjacent parcels with much shallower water depth. So what we're trying to do is get to an appropriate water depth comparable to several of our
And
neighbors.
this exhibit, which is included in the record exhibit, shows where the new pier would be located. Is that right? Just a hand-drawn exhibit?
Yeah.
Okay, and the depth of water it would get to is also referenced there?
Correct.
Okay.
So we have to go to that 202 marker, about 78 feet for that pier itself, to get to about 3 feet of water depth. And Buck will testify much more efficiently than I can about how deep the water is, but basically, we're only sort of at 1 or 2 feet until we get out to that length of the pier.
And is part of the reason for that the peculiarity of the property in terms of it jets inward, so that the property next to you actually extends further out closer to the deeper water, but your property then curves inland essentially, and so you have a larger shoal, for lack of a better word?
Absolutely.
In front of you?
Right.
Okay.
So it's just the unique topography of our particular lot.
It's already in. Yeah.
So So we do think that the hardship is just based on the shoreline. We have no interest in changing the shoreline. There's an existing bulkhead. We do not want to disturb that. We do not want to disturb wetlands. We do not want to disturb anything on the existing property lines. We just want to rebuild in kind on the existing pier.
And in regards to the, in regards to the reconstruction of the pier, in your view, is that the most sensitive thing to do from an environmental standpoint? So you're not going to be disturbing any additional land than what's already underneath the pier, essentially, that exists now?
Exactly. There's no better place to put the pier. Replacing it anywhere else would have a much more substantial environmental impact, which we have no interest in doing. We'd like to just use the existing pilings, the existing footprint as they currently sit, not disturb any wildlife, any natural grasses, anything of that nature, and just rebuild on the existing pier structure.
And is it accurate to say that the pier right now, in terms of where the boat lift is, only gets you to about 3 feet of mean low water?
Just barely 3 feet. Yep.
So you're not trying to go out so you can put some big humongous boat out there or something? No, it's just enough so that you can essentially respectfully wharf out to navigable waters.
We just want to safely be able to dock a regular recreational boat, be able to take the kids out, stuff like that, and just have a safe water depth.
All right, and I'm going to show you a picture. Is this a picture of well, this isn't, well, tell me what it's a picture of.
This one is our pier,
Okay,
or the edge of what currently exists, and then looking forward over the shoals that we've discussed a few times, and you can see the mud. So obviously not really navigable waters right up against the shoreline. So
and is that during low tide? Do you know? when it
good
can happen?
question. We just took the picture when we happened to be there one day, so it might be.
We can
But
assume it's
still,
probably
there's-
during low tide, but it's, and I'm going to show you another picture too, and could you describe for the board what
Sure.
this picture is?
So this is our closest neighbor's pier.
Yeah.
Our closest neighbor's pier, that's my brother-in-law's boat, that's the river packet. So same thing, and we talked about sort of getting to comparable depth. I mean, you can see that she also has a shoal. And in order to get to any sort of water, right, to not have a boat tipped over in the mud, we'd have to go out to that 202 marker.
And do you think there's any reasonable alternative to just simply reconstructing the existing pier in order to get to 3 feet of water, minimal navigable water?
Unfortunately not. The way the shoreline is cut in, there's just no better place to put a pier.
And
There's no alternative.
the river at that location is over 1,400 feet wide, is that correct?
I think it's almost 2,000 feet
Oh,
wide.
okay, almost
Yeah,
2,000 feet.
yeah.
But that's over 1,400.
Yeah.
It is, that's true. But I know you mentioned a sort of 1/2 to the center line standard. I
Yes.
mean, this would be about 1/10 to the center line.
Okay, all right.
The 202.
And did you have a chance to discuss with your neighbors whether or not they had any issues with any of this?
Yes, we've talked to Ms. McIntyre, who's the most close adjacent neighbor. She has no objection. We also talked to Mr. Kimmel, who owns the river packet, the larger boat. We talked to him today. He was over at the house, and he has no objection as well. I think he mentioned he might email Kathy. I'm not sure if that's come through.
We don't accept emails, so you can't take that. You know, I really don't have any further questions for Mr. and Mrs. Schmidt, unless you guys, anybody here does.
Can you share a little bit about the current condition of the deck and why it's necessary to replace it?
It's in disrepair. I mean, if you look at the Google Map images, I mean, it's definitely been let go. So a family owned the property for, I don't even know, 80 or 100 years or something before us, and it was a family farm. It's just been split up, and we bought these 2 lots. So the house was abandoned itself. We've been renovating the house, which had substantial water leaks and things like that.
It's not in a safe condition, is the pier?
No, you can't even walk out on it. I mean, there's a few boards sort of in the front, and then there's boards that are falling apart, so it does need to be
It's not
replaced.
usable in its current condition.
It's in pretty bad disrepair.
Any of the pilings got to be replaced?
Good question. I'm hoping not. We'll defer to the experts. We're going to use, Big Island Adventures is going to build the pier for us. So if they determine when they go out there that it needs to be replaced, we will, but we'd love not to have to disturb them if we don't have to.
They were also the ones that filed the permit with the state.
Been in there a long time.
Yeah, that's true. So if there's any safety consideration, we will. But
Mr. Stevens, did you discuss it? Did you let them know at all about the restriction that we've been putting on all the piers over length as far as being lit?
No, I did not, but go ahead, please.
Would you have a problem, if we were to approve this permit, all the other piers that we've approved in the last couple of years, we've required them to be lit on the end of the pier from
Safety
dusk
light.
till
Safety
dawn
reason.
with some type of safety light?
there is power that runs out there, so that's no problem at all.
I don't have any other questions for the applicant unless you do. I'm going to ask Mr. Park. No, that's not his last name. Just Nickerson. I'm sorry, I drew a blank. Just to come up and testify as to the exhibit and the measurements he took out there, so that you have evidence in the record that the water depth is really not adequate until you get to a little bit over 150
Very
feet.
shallow there, I know that.
Very
the
shallow,
water's
very
shallow. A long way out there, too.
Right. And I'll leave it at this. If you have any questions for Mr. Nickerson, I'm going to give you what you already have in your packet, but this is both the existing and the proposed pier. And it shows all the water depths he's taken out there. And if you have questions as to how he did it, or you have any issues as to that, then certainly I'll call him up and you can ask him, but
Really don't need that.
in the time, okay, don't need it.
I don't think we do.
In the packet.
Already submitted
Yeah.
for the record,
It's already
the
in the
depths are already in
It's
there.
already in the packet, okay.
No one's gonna challenge his expertise right now.
Thank you, Mr. Nickerson.
Said no one's gonna challenge his expertise right now.
No.
So with that, we think that, I asked the board to approve this variance with the condition of the light at the end of the pier is certainly acceptable. And it's the minimal, it's simply an in-kind replacement of something that's been there since probably the 60s on a house that's been there since since for over 100 years. So I think this is certainly one that falls into the category of a variance and the requirements and the criteria that you have. Thank you.
I got to do this. Anyone else in favor of granting this application? Anyone opposing this application?
Sorry.
We're ready for the criteria now.
Okay. Same thing, we have to go through the factors in 18-1-121. First, the factors that must be considered, so I'm gonna go through them and ask whether you have considered them. The first one is the ability to use the property for any reasonable purpose, whether or not such purpose is desired by the appellant in the absence of the proposed variance.
Yes.
Yes.
The degree to which the proposed variance will affect adjacent property owners.
Yes.
Yes.
The impact of the proposed variance upon the resource protection provisions of Part 4, Article 9 of Chapter 18-1.
Yes.
Yes.
Degree to the situation might be more properly addressed by amending Chapter 18-1.
Yes.
Yes.
To grant the requested variance, the board must find as follows. That a literal enforcement of this Chapter 18-1 would result in unnecessary hardship or practical difficulty as a result of the specified conditions.
Yes.
Yes.
Those conditions are peculiar to the property involved.
Yes.
Yes.
Those conditions are not the result of any action taken by the appellant.
Yes.
Yes.
Variance will not be contrary to the public interest.
Yes.
The evaluation of alternatives proves the variance is required.
Yes.
Yes.
Finally, under 122A, the board must find any variance granted is no greater than an amount minimally necessary to ameliorate the conditions given rise to any practical difficulty or unnecessary hardship.
Yes.
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 They need that to get the navigable water.
Okay, that's all of them.
And the pier is in bad shape. Got a motion?
Sure. I'd like to make a motion in regard to case BOA 25080226 for a variance to replace in kind an existing pier with improvements at a total length of approximately 203 feet from the mean high water line, which exceeds the required 150-foot limit. This would be subject to the condition of installing and maintaining overnight safety lighting.
Second that.
All in favor?
Aye.
I now declare this hearing to be adjourned. You will receive a formal decision as soon as possible. This concludes the meeting.
Thank you. Thank you, board members.
Thank you.